Hey everyone, today we are going to talk about unjust enrichment. In contract law, unjust enrichment occurs when one person is enriched at the expense of another in unjust circumstances. When a person is unjustly enriched, the law imposes an obligation on the person who has been enriched to make this thing called restitution, to pay back money, unless he's got a valid defense such as change of position. Now, this concept of unjust enrichment can be traced back to Roman law. In fact, there is a legal maxim in Latin called nemo loco potari potes aliena ictura. What does this mean? It means that no one should be benefited at another's expense. The House of Lords in England, in the 1991 case of Lipkin Gorman, decided that it is a distinct source of law of obligations. The Singapore Court of Appeal in Seagate Technology and Gohan Kim recognized unjust enrichment as part of the law in Singapore. And the court also recognized that restitution, meaning payback money, is a response to an event, usually to unjust enrichment, because if somebody is unjustly enriched by circumstances, he ought to pay back the money. It is also a response to a wrong that is done to another person. The Singapore High Court in Scandinaviska and Asia Pacific breweries held that in order to succeed in a claim for unjust enrichment, the plaintiff, the person suing, has to show that the defendant has been enriched. He has obtained a benefit. That's the first thing. The second thing that the plaintiff has to establish to prove to the court is that the enrichment was at the expense of the plaintiff. The third thing that the plaintiff has to show is that the enrichment was unjust. Things like unjust would be like fraud. Fourth, and the plaintiff has to show that there are no relevant defenses to the claim, such as change of position. When parties are in the course of negotiating a contract, the negotiating parties may confer benefits on one another, whether monetary or services or goods. But because negotiations are going on, the anticipated contract may subsequently fail to materialize. So therefore, because one of them has received goods, services, or money, it is unjust to let him retain the fruits of the goods, services, or money when he hasn't given anything to the other party. It's unjust. He has been enriched. So it may be possible in such circumstances to base a restitutionary cause of action for such benefits if it can be shown that the defendant, the person being sued, had indeed received such a benefit. Let me give you a few examples of unjust enrichment. Number one, money is paid under a void or ineffective contract, such as money is paid under a mistake, or if a contract is void on certain grounds, for example, incapacity, duress, fraudulent misrepresentation, but money has already been paid. Okay, the defendant has already received the money, so it's only right that he returns the money because the contract is void. Another example of unjust enrichment would be total failure of consideration under a contract, because one party has received money under a contract, but he hasn't delivered his side of the bargain, his promise under the bargain, so it's not right for him to keep the benefits. Another example would be work done or goods provided to another where there was no contract at all, so if he received the goods, he should be paid for providing the goods or services. In the event, for example, a contract is rescinded, that means terminated by one party for whatever reason, breach or anything, and money or assets wrongly remain in the hands of the other party, it is also unjust for the defendant, the other party, to keep the benefit of the contract. Now, one important thing to note under the law of unjust enrichment is that there is no double recovery. Although an innocent party can recover under breach of contract and restitution of benefits under the law of unjust enrichment, you cannot claim both. For example, if the plaintiff has paid a price for services which were not provided, a claim for damages for breach of contract must take into account of the price of the plaintiff's expectancy, so that if the plaintiff sues for restitution of the price as well, the damages for breach of contract must be reduced accordingly. So there's no double claiming. He can only claim for the full sum of money that he would have expected to receive. So thanks for watching this video.